To introduce myself, I'm Jeffrey Post. I am a litigator at Fredrikson and Byron, shareholder, and I co-chair our commercial law group, which is a relatively unique group in the firm in that it's made up of both transactional and litigation attorneys that concentrate on supply agreements for goods and services. I'd like to thank everyone for participating today. We had a very high level of interest. I'd like to think as my people are interested in my keen insight on commercial law issues, but I'm also very aware that the deadline for CLE reporting is coming up, and this is probably the most painless way to get your credits, or at least it's a way to get a credits that's probably mildly interesting to some of the participants. That said, to reiterate, if you have a question, please send it to me. Of course, what's a commercial law presentation without disclaimers? First of all, let me note that the title is actually wrong. We're going to talk about 12 recent commercial cases today, and that's because since I put the presentation together, we've had a couple of very significant Minnesota Supreme Court cases, one yesterday in the commercial law space. Secondly, I'm not going to be covering trade secret or non-compete cases. That's sort of outside the realm of what this practice group does. But I will say there have been a number of recent decisions in that area that are significant, and I'm sure that our trade secret non-compete group will be scheduling a webinar in the near future on that issue. Third, there are lots of decisions that have came out during this time frame, so they're subject to my editorial discretion on which ones are the most significant. And I will say I'm human, but I do try to read almost every decision that comes out that applies to Minnesota law in the commercial context. Finally, the disclaimer that needs to be in every presentation, although we're certainly discussing legal matters, I'm not offering legal advice in relation to a specific legal issue that you may have, and the intent of this webinar is not to form an attorney-client relationship. Having went through the disclaimers, I want to talk about some of the macro trends that are evident in the cases in the last 18 months or so. There have been a real wealth of cases on contract interpretation by either the 8th Circuit or the Minnesota Supreme Court. I would say more cases in the last couple of years than the preceding 5 years. And so there's a lot more guidance for transactional attorneys on contract meaning. Secondly, the other macro trend that's apparent in the case law is that warranty claims from a plaintiff's perspective have been treated more favorably in the last several years. There's a greater chance of a meaningful recovery under the recent case law. Conversely, the third trend is that fraud claims are treated less favorably. Part of that is a function of the Rule 9 requirement that fraud be pleaded with specificity. Part of it is the recent evolution in the standards for stating a claim under the Trombley-style cases. Although I'll mention some of the fraud cases tangentially today, I won't have as much in-depth discussion about them because there really hasn't been much evolution in the law. It's just that the courts have been finding that you need to plead the who, what, where, and why with specificity. And if you don't do that, you're not going to be able to recover. The final macro trend is that there's been some clarification on what sort of damages are recoverable and what sort of proof is necessary to entitle a party to recover those damages. With that, I want to first go to the first topic, and that's the cases that deal with contract interpretation. The first case we're going to discuss is the Quinstar Corp versus Anthony. This is an 8th Circuit case, relatively recently, in the last few months, a 2018 case. The factual background in this case is that you had two companies that were competitors in selling and repairing old IBM check processing systems. Not surprisingly, this was a shrinking market, and so there was an economic incentive for the two companies to merge. The seller in the case, who is the defendant, prior to the deal, had provided the buyer, and this is an asset purchase agreement, so he had provided the buyer with an inventory list that listed the value of the inventory at $4.7 million. On the buyer side, no one ever took an inventory at any time, either prior to the sale, on closing, or after the sale. The asset agreement was structured for a sale price of $50,000 for the assets, but then a 5-year employment contract for the principal of the seller for $200,000. The APA provided that the seller was selling the inventory that it had on the date of execution. And what the dispute was about is the buyer terminated the contract, and their claim was, look, the seller represented that the inventory is worth $4.7 million, but what we actually got was inventory that was worth much less than that. And then the seller counterclaimed against the buyer, and his counterclaim was that, look, they terminated my 5-year employment agreement and after 2 years, and I'm entitled to 3 years of compensation. So the first part of the decision deals with the claim by the buyer that they didn't get any of the inventory. And the buyer was going to try to prove its claim by introducing evidence of the value of the inventory, the $4.7 million statement that was 3 months prior to the closing or to the execution of the APA, and some evidence that there wasn't as much inventory now. What the court said is that the evidence of the inventory 3 months prior to closing was parole evidence regarding the value of the inventory, and that the plaintiff in the case, the buyer, had no proof about what the inventory was at closing. It hadn't done any inventories. Therefore, it failed to meet its burden of proof, and the seller, or defendant, was entitled to summary judgment. So the first two headings, the parole evidence of prior agreement is inadmissible, and a merger clause establishes the parties intended the writing being integration of the agreement, dealt with the affirmative claim by the buyer against the seller. The court then got into the issue of whether or not, how to interpret the portion of the APA that dealt with the salary for the seller in the case. And in analyzing that, the court did find that that clause was ambiguous, and at the district court level, the district court jumped to the end of the analysis and said, because the buyer was the drafter and the term was ambiguous, the terms were ambiguous, they should be construed against the drafter, and therefore the seller, the defendant in this case, and the counterclaimant should win on their claim. What the Eighth Circuit said is, no, you really just can't jump to the end of the process. You have to go through these steps of interpretation in order to determine what the meaning of the terms in the contract are. In the maxims of interpretation the court dealt with is that the courts should construe the contract as a whole and attempt to harmonize the clauses, and in doing that, the court will try to avoid construction of the contract terms that renders a provision meaningless. Where there's an apparent conflict between two provisions, it's the court's duty to find harmony and reconcile them. And one of the tools in doing that is to give full effect to principal and more important clauses, and subordinate the clauses that are of more minor importance. So, and going through, and then at the end of that process, if the intent of the parties isn't clear, then you get to the canon of construction that ambiguity should be construed against the drafter. The end result of the court's analysis in that case was that there's still a fact question regarding what the ambiguous language means that a jury needs to determine. And because it's ambiguous, the parties can introduce parole evidence regarding the meaning of that evidence. But I would say if you're routinely involved in the drafting of contracts, this Quinstar case is a case that I would have by my desk because it goes through the canons of construction in a very detailed way and contains all the citations to the relevant Minnesota precedents. A very useful case in that sense. So just yesterday, the Minnesota Supreme Court came out with a decision that is consistent with the holding in Quinstar. And it says, this is the Staffing Specifics, Inc. versus Tempwork Management Services, Inc. There's no citation because it's so new, but the case number is A16-1146. And it says, first of all, the case holds that any determination of whether a contract language is ambiguous or not is a legal question. It's not a jury question. That's not a surprising result, but it's one that the Supreme Court clarifies and reiterates. And secondly, the court holds that only if a preponderance of the evidence fails to establish the party's intent on an ambiguous term, because the court makes it clear it's the intent of the parties that should control, and that intent, if the terms are ambiguous, can be established through parole evidence. But only if that intent cannot be established do you go to the canon of construction that says that the terms will be construed against the drafter. And so that canon of construction in the context of contracts where the parties have relatively equal bargaining power and it's not a form contract, it only comes into play if the evidence can't establish the intent of the parties. So the practice tip that I would take away from the Quinstar case, and it's not something I came up, it's actually in the language of the case, is that the circuit chides the buyer and says, look, if you wanted to define what inventory you were purchasing, you need to include an inventory schedule in the asset purchase agreement. So it sort of seems simple in hindsight, but it's stuff I've seen come up in some of the litigation that I've handled and something I've advised my clients on. If you have an integration clause and you have an undefined inventory, absent proof of ambiguity and inspection and inventory list, you may have a very hard time sustaining a claim for the failure of the buyer to provide all the inventory, the failure of the seller to provide all the inventory the buyer thought they were purchasing. So the next case I want to cover is the Glacial Plains Co-op versus Chippewa Valley Ethanol Company case. Brief factual background on this case. Chippewa Valley wants Glacial Plains Co-op to invest in the ethanol plant. Chippewa Valley Ethanol Company is an ethanol plant. During the formative stages of the venture, they entice Glacial Plains Cooperative to invest in the plant, and they do that by giving Glacial Plains land next to the plant for a grain handling facility, and providing that during the contract's term, the plaintiff, Glacial Plains Co-op, will be the exclusive grain handler for the facility. Now, if we look at the problem is that what's the contract's term? And in paragraph 1, this is the actual language from the contract. This agreement shall continue indefinitely until either terminated by the terms of this agreement or by the mutual agreement of both parties. Now, the issue of construction that arises when you have an indefinite contract. This is, what is the contract term? And the general rule is that contracts of perpetual duration are disfavored by public policy. So if you're going to have a perpetual contract, you need to be explicit and unambiguous in communicating that. And to the extent contract language regarding term is ambiguous, then it will be construed against the contract being of perpetual duration. So the district court in this case sort of ignores and the other corollary to that, a contract of indefinite duration, so if there's not a definite duration to it, is terminable at will upon reasonable notice to the other party after a reasonable time has passed. And so the district court says that even though the term language uses the term indefinitely, making it potentially terminable at will, we're going to look at the other circumstances around this, the fact that the contract could only be terminated upon breach or mutual agreement of the parties, and the fact that the contract was entered into to solicit investment, and we're going to hold that it was for a perpetual duration. The court rejected that and said, look, we're not going to avoid ambiguity through inference. And to the extent that that term is ambiguous about whether it's perpetual or not, it'll be construed against being perpetual, and we'll find it terminable at will. And so what the Supreme Court did is referred the case back down to the district court for factual findings on whether the notice period was reasonable and whether a reasonable time had passed. So the practice tips to draw from this case is that if you want a contract to be perpetual, you need to use terms like perpetual, forever, or permanently. Those terms come right from the Supreme Court's decision. If you want a contract to be indefinite and you want to avoid a fight upon the contract breaking up, you need to define what the minimum term is, what a reasonable minimum term would be, and what the reasonable notice period would be. The next case I want to turn to is the DeWitt versus London Rental Center case. That's another Minnesota Supreme Court case from this year. In that case, the plaintiff in the case is someone who attends a party at the Tower Tap. The Tower Tap has an annual party. It's a restaurant bar on the country. It has an annual party for its patrons. As part of that party, it rents tables from the London Rental Center. So the plaintiff attends that party. During the party, one of the tables collapses and the plaintiff is severely injured. Plaintiff wins on liability. The question now is, who's going to be responsible for the plaintiff's damages? And the London Rental Company says, look, we have a very broad indemnity clause, and it provides that we're indemnified for everything except our own intentional conduct. The court, though, in examining that clause says, yes, it indemnifies you, London Rental, for everything. Well, the tables were in the possession of the rentor, but maybe this negligence proceeded. Maybe it was the way that you maintained the tables prior to the tables being rented. Therefore, there's some ambiguity in whether the indemnification clause applies. And as a matter of interpretation, the Minnesota Supreme Court disfavors indemnification clause than indemnification clauses that indemnify a party for their own negligence. And the court won't infer indemnification. And so unless there's an express language indemnifying a party for its own negligence, the court won't find indemnity. Now, this case is somewhat at tension with the recent result, another recent Eighth Circuit case, DeWitt, Feed Management Systems, Inc. versus Comco Systems, Inc. In that case, the court found that the broad language of the indemnification clause made it clear that the party was indemnified for its own misconduct. And so be careful, especially in-house counsel, if your outside counsel is relying on that feed management systems case. The DeWitt case would be controlling in Minnesota. It's actually Minnesota Supreme Court precedents as opposed to Eighth Circuit interpreting what the Minnesota Supreme Court would be. The practice tip out of DeWitt is that if you want to be indemnified for your own negligence, you need to use that term. I realize that creates issues in the context of contract negotiation because you're making it clear that the other side's liable for your negligence, but it's unlikely that you can creatively draft around the need to be explicit. So I next want to turn to the topic of statutes of limitation. Troublehorn versus Argwell. It's a Minnesota Court of Appeals case from 2017. And the factual background is that the defendant, Mr. Argwell, owns a gas station, and he's buying gas from Mr. Troublehorn. And at the start of this relationship, the defendant first enters into a credit agreement where he personally guarantees payment of this by the purchases by his business of the gas. But then after that, Troublehorn and Argwell enter into a supply agreement, and it says Argwell and his business, he has a corporation, are jointly and severally liable for all payments due under the supply agreement. And that supply agreement contains an integration clause that says any previous agreements go away. And so what happens is that more than 4 years after Mr. Argwell or his business failed to pay for the gasoline, Troublehorn sues. And so the question is raised about what the applicable statute of limitation is. And Troublehorn's claim is, Argwell's claim is, look, this is a 4-year statute of limitations. It's a sale of goods. Troublehorn's claim is, no, it's a 6-year statute of limitations because Argwell is a guarantor, and a guarantor is a different contractual obligation than the sale of goods. The court first examines about the question of whether Argwell is a guarantor or not. And the court actually finds that he is a co-maker because he is jointly and severally liable. And a co-maker is a party to the contract as opposed to a guarantor. Conversely, the court finds a guarantor is not someone who's jointly and severally liable, but instead their liability depends on the performance of the principal. So the court finds that Mr. Argwell is a party to the contract, not a guarantor. And so the issue then becomes, the issue is whether the claims are barred by the 4-year statute of limitations. Troublehorn tries to avoid that result. The plaintiff in the case tries to avoid that result by claiming, look, I have a claim for accounts stated, separate from my UCC claim, and that's also subject to the 6-year statute of limitations. The Court of Appeals rejects that and says Minnesota law does not allow us to determine the applicable statute of limitations based on the remedy. Instead, it's determined by the nature of the wrong. And when the underlying transaction is the sale of goods, in this case gasoline, the 4-year limitation applies. So what are the practice tips that we get out of the Trouble Horn case? First of all, you need to think carefully about the impact of an integration clause. Are there previous agreements that you need? In this case, the integration clause got rid of a guarantee that would have sustained the lawsuit in this case. Secondly, you should spill out the status of the parties to the contract to find whether they're a co-party or a guarantor. And thirdly, you need to look closely at the conduct that gives rise to the cause of action. Again, it's not the remedy that you're seeking that determines the statute of limitation. It's the underlying conduct that gives rise to the cause of action. The next case is the Hardy Plank Fiber Cement Siding litigation. This was a multi-district litigation case that ended up being venued in Minnesota. There are a variety of state level UCC issues that were determined in this case. This was a class action case, and there were a variety of class representatives from all over the country. The court does a very thorough analysis under each state's version of the UCC of those claims. I'm only going to talk about the Minnesota claimants. And the significance of this case is that the defendant in the case, Hardy Plank, was selling siding. The plaintiffs claimed or alleged that the siding would delaminate, and that would allow moisture to enter into the building. So the plaintiffs sue. They think they're timely under a 4-year statute of limitations or potentially a 6-year statute of limitations. The court finds that the 2-year statute of limitation applies, though, and that statute applies to the recovery of damages for any injury to property arising out of defective and unsafe condition of an improvement to real property. And the court goes on to define what unsafe means. And unsafe, in order for something to be unsafe, sort of counterintuitively, the court finds that the product doesn't have to be dangerous. It just has to render the property insecure and vulnerable to invasion, such as a door or window which fails to provide the expected barrier against unwanted elements. And in the plaintiff's allegations, this particular plaintiff's allegations, not only did they allege that the siding delamitates, but that delamitation allowed water to penetrate the house. So the practice tip from the Hardy Plank litigation is that if a claim involves even tangentially an improvement to real property, then you need to be aggressive about addressing it if you're on the plaintiff side. Conversely, if you're on the defense side and you've sold a good and it's incorporated into real property, you need to keep in mind the potential application of this statute. And where you get into some interesting questions is, and I don't have the answer for you, unfortunately, today, but I want to throw out the topic for you to think about is, what's an improvement to real property? To me, a new roof obviously is, but what happens if you put in a new safety ventilation system in your factory? Is that an improvement to real property that triggers the 2-year statute of limitation as opposed to a 4 or 6? So, again, that illustrates the practice tip that if it's arguably an improvement to real property, you need to be diligent about your potential cause of action. Next, I want to move to the topic of warranties. This is a chart that I came up with. We've used at a variety of presentations. Something we share with our clients, and this is a chart that sort of allows you to do a flow-through analysis about whether a buyer can maintain an implied warranty claim. And the next case that we're going to address is dealing with sort of that third level analysis. Are those disclaimers effective under Section 2316 of the UCC or under the common law? If the disclaimers are effective, it cuts off an implied warranty claim. If they're not, then the analysis continues. So case number 6 is the Sorgacha versus Ride Auto LLC case, Minnesota Supreme Court case from this year. And the facts are that the defendant got a truck, the defendant auto dealer got a truck from a junkyard and knew that the truck needed a new engine. Brings the truck to the lot. The plaintiff comes along, test drives it. Test drive is short because the truck doesn't have much gasoline in it. But during the test drive, the check engine light comes on. Plaintiff says, "What's that?" Defendant says, "No problem. Just probably the oxygen sensor. The gas cap's probably not on tightly. Don't worry about it. Not an issue, easy fix." Defendant buys the vehicle, signs it, gets the disclaimer as is, no warranties. The question is, under these circumstances where in the court and the jury did find fraud in this case, that the defendant knew that the condition of the vehicle wasn't as represented, that it wasn't a minor repair, that it needed a new engine. Under these circumstances, would the warranty disclaimer be enforceable? And if it wasn't enforceable, could the plaintiff recover both on theories of breach of warranty and on fraud? So the first issue about whether the disclaimer is enforceable or not is controlled by Minnesota Statute 336 to 316 3A. And that provides that the disclaimer is enforceable unless the circumstances indicate otherwise. And the Minnesota Supreme Court had never determined what circumstances indicate otherwise means. And the court goes on to find that fraud is circumstances that indicate otherwise. So the disclaimer isn't enforceable and the plaintiff can maintain an implied breach of the implied warranty of merchantability claim. Then the court goes on to find that the defendant can not only rescind the contract, but they also can pursue the remedies under the UCC because the UCC provides both for rescission and any other remedies provided by Article 2. So the significance of it in the consumer context is that the plaintiff can rescind the contract, seek incidental consequential damages, but I think more importantly for this particular plaintiff, get relief because they're a consumer under the Magnuson-Moss Warranty Act, a federal law that allows attorneys' fees for claims of breach of warranty, including breach of implied warranty. In the non-consumer context, the importance of the case is that in evaluating your litigation risk, you need to be aware that just because a party rescinds a contract doesn't prevent them from seeking other UCC remedies like consequential damages. This is a chart similar to the first chart, but deals with the issue about whether you are liable for a breach of warranty claim. So the first chart dealt with whether an implied warranty exists. The second chart deals with whether you're liable for breach of an express or implied warranty. And the issue that we're dealing with is sort of 4 levels down the chart. Is there an exclusion of incidental consequential damages? And if there is that exclusion independently enforceable if the exclusive remedy clause fails of its essential purpose? Just as an aside, I would say my practice is national in scope, and Minnesota really does have a very well-developed body of UCC Article 2 law, in part because windows. We manufacture a lot of windows in this state, and windows are difficult to manufacture. They're tricky, and when they go bad, people get upset by them, and if they're also fairly expensive, and if a lot of them go bad, it generates a lot of litigation. So because we have a large amount of manufacturing for a state our size, and because in particular we have window manufacturing, we really do benefit from a more robust body of law than a lot of other jurisdictions have in the context of Article 2. And with that aside, I want to move to case number 7. That's the Lucky versus Allside case. This is a case where the plaintiff in the case claims that the insulated glass unit windows that it purchased are defective. There are all sorts of problems, sort of typical ones, fogging, leakage, that sort of thing. The defendant in this case does the right thing, I would say, in that they provide free replacement windows. And they say, look, here's our exclusive remedy. Our exclusive remedy and warranty is that we repair, replace the windows. We have replaced all the windows. Now, they just give the windows. They don't cover the removal or the installation. So the court first goes into the analysis of when a limited remedy of warranty of repair and replacement might fail of its essential purpose. And I think the particular benefit of this case is that you get a summary in one place of the 3 circumstances that may cause an essential remedy to fail, an exclusive remedy to fail of its essential purpose. 1, where the seller is unwilling to repair or replace the defective item. That's sort of self-explanatory, or unwilling to do it within a reasonable time. 2, the seller is unable to successfully repair or replace the defective item. And in other words, they attempted repair and they couldn't correct the problem. 3rd, and this is a relatively recent one, exception, the limited remedy is insufficient because the foreseeable incidental and consequential damages greatly surpass the cost of goods or the cost of the available remedy, such that even if the seller repairs or replaces the defective item, the buyer incurs proportionally large costs dealing with the defect. And that case comes out of the Marvin Lumber and Cedar Company versus Sapa Extrusions case. That's a 2013 case, 964 F sub 2nd, 933, District of Minnesota. It really is, for manufacturers, it really is a case worth reading because this exception hasn't been fully litigated yet, but really has a potential to support far more findings of failure of essential purpose, or at least create fact issues. The other thing I should mention, and it's on the previous slide, so I'll just turn back to it. The seller in this case had a disclaimer of all warranties. The court held that a disclaimer of all warranties is insufficient to exclude the warranty of merchantability because it doesn't mention merchantability. So you need to make sure that your disclaimer mentions merchantability. The other thing that the court found, and this is a bit of a change, or at least a change from the commercial or the non-consumer side, the business-to-business UCC litigation, is that if a limited remedy fails of its essential purpose, then a separate clause excluding consequential and incidental damages is unenforceable, even if it's unconscionable. I think this is consistent with some of the dicta in earlier Minnesota cases, but this is the first explicit finding of it. Conversely, in the commercial, the business-to-business claims, the case law is that even if the exclusive remedy fails of its essential purpose, the clause excluding consequential and incidental damages would be independently enforceable. So the interesting holding as far as the Lucky case is that even though Allside, the defendant in the case, had replaced all the window units, because the defendant in the case, because the plaintiff in the case alleged that there was a design defect, there was at least a fact issue of whether or not the exclusive remedy had failed of its essential purpose. So the practice tip is make sure you're reviewing your warranty disclaimers on a regular basis to make sure that the disclaimers are enforceable. The law is constantly evolving on that subject, and you want to make sure that you're up to date. The other practice tip is that always include the ability to refund in lieu of repair or replacement. There's a very good Minnesota case law out there that says that, look, if you can't repair or replace, if you give a refund, the exclusive remedy doesn't fail of its essential purpose. So the next case, which is actually decided about 2 weeks later, and as opposed to Kiefer, you could refer to the plaintiff in this case as unlucky compared to the previous case, lucky. In this case, very similar fact situations. Plaintiff sues Symington Building Products, claiming that it purchased defective windows. Defendant provides repair and provides replacement windows. The plaintiff's claim is that, look, the exclusive remedy in this case is unconscionable because of the additional costs relating to installation and disposal that the plaintiff had to bear. And the court goes into a very detailed discussion, the most detailed discussion I've seen about what unconscionability means in the context of Article 2, and says that unconscionability has both a procedural and substantive aspect, and you have to find both to avoid the terms of the contract. It says that a contract is procedurally unconscionable where a party demonstrates it has no meaningful choice but to deal with the other party and to accept the contract as offered. The contract is substantively unconscionable if its terms are unreasonably favorable to one party. But the court goes on to say that merely pointing out that warranties are non-negotiable and that the parties possess unequal bargaining power is insufficient to avoid the contract. And then goes on to say that the use of a standard form contract between two parties of admittedly unequal bargaining power does not invalidate an otherwise valid contract provision. And the court recognizes that, look, if we just invalidated standard warranties across the board, we'd really rob sellers of meaningful protection in limiting their liability. The court goes on to hold that as far as substantive unconscionability, that because the UC specifically provides for exclusive repair and replacement remedies, they can't be substantively unconscionable. I guess the practice tip, it's sort of self-evident, but it is important, is it's very difficult to prevail on unconscionability defense. So to the extent that you have your internet click-through terms, or you have your standard warranty that comes along with the packaging, or it's your standard form contract purchase agreement, it is difficult for the other side to prevail on unconscionability defense. Not impossible, but difficult. So the next topic is a little bit of a potpourri. We'll talk about, I think, the most significant damages case. We'll talk about a potential defense to a tortious interference claim. And then finally, we'll talk about waiver of arbitration. So the Luminera Worldwide case, in this case, the plaintiff provides faux candles, those candles that are battery operated but look like they're real candles. The defendant in this case signs up to be the distributor, and they can purchase these candles only from the plaintiff during the term of the distribution agreement. There's also a 12-month non-compete, post-contract non-compete period. During the course of the distribution relationship, defendant purchases candles from another supplier. Distribution agreement in question excludes consequential damages. Plaintiff sues for lost profits. The question that's presented, I think it was Judge Nelson that handled this, and it's really a well-written opinion. Anyone that's sort of dealing in damages and struggles, because I get this question from my clients all the time: what the heck are consequential damages? At least in the context of lost profits, it's a very well-written, well-reasoned opinion. I really encourage people to take a look at it. I can highlight it, but I don't think my highlights do it justice. But the basic case law is the Minnesota Supreme Court has defined damages, direct damages, those damages that arise naturally in the usual course of things from the breach itself. In contrast, consequential damages do not arise directly according to the usual course of things from the breach itself, but rather those are the consequences of special circumstances. Several courts have summarized the difference by noting that direct damages cover losses arising from the contract itself, while consequential damages cover losses on other contracts or relationships. And then the court has an example that I found helpful. For example, a general contractor who sues for expected profits from a beach construction contract, the lost profits are direct damages. In contrast, if the defendant's breach caused the contractor to close shop, precluding him from performing work on other active contracts, the lost profits from those contracts are consequential damages. So what Judge Nelson finds is that because the clause only covers consequential damages, and the damages that the plaintiff is seeking, the profits from the lost sales, the plaintiff lost because the defendant was buying from another source, are direct damages. But the court distinguishes and says that the damages that arise from the 12-month non-compete are consequential damages, and cites to some Eighth Circuit law to that effect, and says that those post-term non-compete damages are more akin to new contracts and more akin to consequential damages. So the practice tip is an exclusion of damages clause should specifically exclude or explicitly exclude lost profits. I'll throw out the caveat that such an exclusion might not be enforceable because it might leave the plaintiff in a potential case without any sort of remedy. And although there hasn't been a case directly on point, I would submit that the Marvin Lumber versus Sapp Extrusions case that I referenced, it's not one of the highlighted cases, it's the 2013 case, although not directly on point, supports that result potentially. So case number 10, and we're almost there, and I'll try to be brief on these last two and leave a little bit of time for any questions. Scholar case, plaintiff sues over a deal to develop a grain storage and transit facility that collapses. The contract claims I'm not really going to talk about because they were governed by Canadian law, but the tort claims were governed by Minnesota law, and the plaintiff scholar makes a claim for tortious interference, claiming that the subsidiary interfered with the parent's contract with the plaintiff. The defendant's response is that, look, generally there's a privilege that says that parents and subsidiaries can't be liable for tortious interference with the other's contract. So there's a general principle that the case recognizes under Minnesota law that generally a party cannot tortiously interfere with its own contract. And the court acknowledges that some courts have extended this principle to establish a parent-subsidiary privilege under which a parent and wholly owned subsidiary cannot interfere with the other's contracts. The court, though, at least at the summary judgment level, doesn't apply the privilege. It says, look, there's no Minnesota case law on this. Because it's usually the privilege is found in the context of the parent interfering with the subsidiary, not the subsidiary of the parent. I'm not sure if the rationale applies. Therefore, I'm not going to find that as a basis for summary judgment. As an aside, too, also note that this case contains an excellent analysis of a damages expert's ability to rely on internal company projections and opine about future lost profits. I know my friend and damages expert extraordinaire Art Cobb was signed up for this clause. I'm sure he's aware of the case, but to the extent your in-house counsel and your outside counsel is using a damages expert, make sure they're aware of this case. It really is a very good discussion about a Daubert motion that claims that the damages expert relied too much and was just parroting the plaintiff's internal projections as far as the lost profits claim. And the court ultimately rejected that, but you can get into the details of sort of what an expert has to do to be able to rely on those claims. So the practice tips out of this case: 1, include a clause that precludes any tortious interference claims against a parent or a subsidiary to a contract, or a minimum makes any clause limiting remedies or excluding damages apply to a parent or subsidiary to a party to the contract. So because the privilege hasn't been recognized, you're better off explicitly carving that out in your contracts. So the last case, and I appreciate everyone's attention today. This is Messina versus North Central Distributing. North Central Distributing is a DBA. Its DBA is Yosemite. In the case of the defendant is Yosemite. So Messina is a former employee, sues Yosemite for breach of contract. Yosemite removes to federal court, answers, goes through the Rule 26 report drafting and conference, moves to transfer, then loses, and then at that point moves to compel arbitration because there was an arbitration clause in the parties' employment agreement. So as a backdrop, as most people are probably aware, there's a strong policy is enshrined in the Federal Arbitration Act in favor of arbitration. Any doubts concerning waiver arbitrability should be resolved in favor of arbitration. But the court goes on, the circuit goes on to lay out the standard for waiver. 1, that the party knew of its existing right. 2, acted inconsistently with that right. And 3, prejudiced the other party by these inconsistent acts. And then the court goes on to say that the test is if for acting inconsistently, if they've substantially invoked the litigation machinery prior to moving to compel arbitration. And the court goes on, this is the last bullet point. Yosemite moved to compel arbitration after it lost its motion to transfer venue. The timing of Yosemite's actions demonstrated that it wanted to play heads I win, tails you lose, which is the worst possible reason for failing to move for arbitration sooner than it did. And I mean, I can tell you, and I followed this case to see what happened in the case, and maybe not coincidentally, the Yosemite also lost on their summary judgment motion. And I can tell you from my own experience, nothing frustrates judges more than this sort of gaming of the litigation system, and you really put your client at risk. And so I guess the practice tip is don't be a Yosemite. Be diligent in asserting your arbitration rights and don't game the system. You'll end up in a worse place. I want to thank everyone for your attention. I appreciate being able to discuss the cases with you.